Well, thank you, everyone. It's a delight to be here with so many friends, professionals, scholars, and innovators. My name is Tony Lai. I've been a fellow here at CodeX for the last 6 years now, and I'm the CEO and co-founder of a company called Legal.io. We build legal marketplace infrastructure and referral management solutions. But it's my biggest honor to be here on this stage to introduce to you all the session I know you've all been waiting for, the lightning rounds. To mark our 5th year doing FutureLaw, we have 5 tremendous speakers for you who are going to give you 5 distinct presentations that speak to the future of the legal industry and the legal profession. Yet inspired by Professor Gillian Hadfield's phenomenal keynote earlier, I think we can see how the message of our speakers will actually go further. Because these rules, this legal infrastructure, this collective storytelling machine, these are necessary for all of the grand challenges that our world and our local communities are going to face. We've just heard about the rise of chatbots, and that's where our first talk will pick up, from the perspective of what these sorts of technologies mean for legal education. We're going to end with why law firms should embrace matter standards, as we hand off to the next session, where we'll hear from the customer's perspective, and the growing focus on customer value as a metric for successful delivery of legal services. Each speaker will have 10 minutes for their talk, and I will introduce each of the speakers before their talks, as we go on this journey from robo-lawyers, humans and machines, via transparency and access, innovation, social inclusion, and through to customer value. I'm going to ask you to think about and hold your questions to the end after all our speakers have spoken, and we shall see what these threads we can pull out and weave together into a tableau for the future of law. We've already had some tremendous threads and insights from the conference thus far. And our first speaker is going to pick up on one particular set of threads. How are we preparing our future lawyers for all that we've been talking about? How are students being introduced to technology today? How do we train lawyers to be entrepreneurial? How can we embed legal knowledge in more efficient tools? How do we teach the business of law? Professor Jeanette Ikes is the co-director of the Center for Legal Innovation at Vermont Law School. She teaches and facilitates collaborative projects between students, faculty, and industry partners. She has publications on educating the digital lawyer and has experience serving as CEO of an application development and internet consulting firm, managing information technology for Vermont Law School, and establishing several unique degree programs during her tenure as professor at Vermont Technical College. Jeanette Ikes on legal education reform in the age of the robo-lawyer.
Thank you, Tony. So I'm here to talk to you today about the future of law, specifically future law in law schools. And law schools are future law in a very real way. We prepare the next generation of lawyers. So the question I have for you today is, are we excited by this? Is this good? Is it good that law schools are launching future lawyers in the sense that they're responsible for creating those who are going to innovate a new future and transform the legal profession, if indeed it is meant to transform? So what was my first response from colleagues when I started talking about changing the doctrine, adding topics? I want to teach legal technology in the classroom. I want to teach about law practice management. I want to teach the business of law. And I think this slide pretty much reflects the response I received. They looked like they had unbearable migraines, and I was the source. So this in fact, in the beginning, was the way it was. We feared change, and they hated everything. I brought it up, and they said, why would we want to do that? So I'd like to say that now we're past that. And law schools, in fact, are at the edge of change and hope. Hope for the future of the legal profession, and hope for our students that are graduating, whether they're going to be lawyers in the legal profession or they're going to find other careers that leverage the skills they learn in law school. So, as Desmond Tutu said, hope is being able to see that there is light despite all the darkness, the fear of change, the headaches. And who are these spots of light? It used to be I put 10 schools on a slide like this. I couldn't fit them all on the slide now. Law schools are changing. So I was brought here to talk about 5 because it's 5 years of CodeX. So let's talk about 5 innovative ways law schools are preparing the next generation of lawyers. And the first way I'd like to discuss with you today is we're incorporating technology into the teaching of law. Now, what do you care about that, right? Here you are today, and we're supposed to be talking about how we're innovating in law. And I'm talking to you about using some slide projectors in the classroom. No. I'm talking to you about gamification. I'm talking to you about teaching law students using games. This is Adam Kandub's game Criminal Procedure from Michigan State. And I borrowed some slides, or a slide shot from him. This is a perfect example for how we're creating immersive simulation environments for law students so they can experience what it's like before leaving the classroom and while learning the law. This is Oklahoma. This is Professor Fox at the OU College of Law. Do you know what that is that the law students are in? That's a virtual reality system. They're actually going through, monitoring evidence collection, looking at chain of custody, all within a virtual reality environment. This is augmented reality, or as some folks are calling it, thanks to a blogger in Michigan, augmented legality. All right. This is how prosecutors in the future will be following along with police as they investigate a crime scene. And we're bringing this into the classroom so that they can see how this is being done. And this is actually a school in Westminster, England, a law school that's doing this. Next on our top 5, adding technology competency requirement. What do I mean by this? I mean you have to know about technology to graduate law school. Whoa. This is insane. This is so important because as we all know, there is a rule. And the rule says, the ABA Model Rule 1.1, Common 8 says, to maintain the requisite knowledge and skill, a lawyer should keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology. It's required in the model rules. Why aren't we doing it in law schools? Well, one law school is. One law school so far, I have hope, as we said earlier. Requirements for the JD degree at the College of Law, UNT, Dallas College of Law, which is new and not fully accredited yet, and maybe this is why they could do this, has said that completion of the writing requirement, skills requirement, research requirement, experiential requirement, and practice-related technology requirement is needed to graduate from law school. Number 3, we need to teach the business of law. We need to teach lawyers before they go out what a trust account is. We need to teach them some other more innovative business practices too. We need to teach process and project management. We need to teach process improvement. 6 Sigma for lawyers, lean. These are all topics that we need to be talking to our students about. Because law is a business, and you do have to eat and pay back your law school loans, right? What are some other parts of law as a business? There are too many to mention. We put them into a course. Many schools put them into courses now. We teach social media, we teach client-centric law practice, We teach about collaboration and the importance of not just an adversary, being an adversarial lawyer, right? You have to collaborate with the opposing side. We teach about legal data science. My goodness, it's a different world. The next way we're improving law schools and we're innovating, we're teaching students to embed legal knowledge in technology tools. So everybody saw the wonderful New York Times photo of the lawyers sitting on the floor in the airport, and they were helping the immigrants as they came through, right? I think if they had been to law school today, maybe they would have known a better way. The lawyers would have still been there, but maybe they would have had some other tools. Maybe they would have flowcharted this immigration law. They would have looked at it. They would have understood the legal process. And then they would have done a little legal knowledge engineering. They would have embedded that knowledge into an app. They would have been able to spread out, take more people, help more folks. This is the heart of making scalable legal solutions to help access to justice. And this is something we are teaching in law schools. Finally, we need to teach our law students how to think like lawyer entrepreneurs. What is a lawyer entrepreneur? Funny story, the other day I was sitting with a colleague and I was talking to her, and I was talking to her about creativity in law. And she said, I didn't know lawyers were creative. I said, of course we are. She said, but what do you mean? And so I told her. I told her about students that were building apps for social justice or building apps for commercial reasons. So those students that you just saw, they put together an app called Pocket Lawyer. And this was the DUI model of Pocket Lawyer. And this was for the person when they see the cop car behind them, pulling them over, and maybe they've had a few, right? And these are students that were sensitive enough to know how to design an app for people that maybe had a few. Notice how big the buttons are? Right? So they're thinking about their clients, they're thinking about their consumers, they're thinking about the situations, and they're making law approachable and usable. And then they pitch the idea. They pitch the idea to people who can fund their ideas. They pitch the idea to law professors. They pitch the idea to stakeholders. And then they turn the code over to the stakeholders and give them a license in perpetuity to use the code for their purpose, whatever it is. So these are the 5 ways that I chose to bring to you today that law schools are really innovating. They're incorporating technology into teaching law. They're adding technology competency requirement. They're teaching the business of law. They're teaching students to embed legal knowledge in technology tools. They're teaching lawyers to think like entrepreneurs. So there is hope. Out of the deserts that were law schools, we have new ideas sprouting up. Thank you.
Thank you, Jeanette, for that uplifting perspective on how the Academy is being invited into and, frankly, being moved to action by some of the provocations, I think, that our community here is sharing. So a really valuable perspective. Thank you. So staying with the Academy for a moment and building on the project-based learning thread, I've had the pleasure of knowing our next speaker since I first came to Stanford. And we've been fortunate to cross paths many times as part of our shared mission to increase access to justice through better design and technology. Margaret is living proof of the value of what Jeanette just shared with us. In fact, to get even more meta, while a student at Stanford, Margaret built the game app, Law Dojo, to make studying for law school classes more interactive and engaging. Margaret Hagan is a uniquely talented individual who combines her background in law with a wealth of experience in applying the methodologies of design thinking. And you'll be hard-pressed not to love her beautiful visual storytelling aesthetic. She's the director of the Legal Design Lab here at Stanford and a lecturer at Stanford's D School. She was a fellow there from 2013 to 2014, where she launched the Program for Legal Tech and Design, experimenting in how design can make legal services more usable, useful, and engaging. She teaches a series of project-based classes with interdisciplinary student groups, tackling legal challenges through user-focused research and design of new legal products and services. She also leads workshops to train legal professionals in the design process to produce client-focused innovation. She's a graduate of Stanford Law School and also started the blog Open Law Lab to document legal innovation and design work. Picking up on the thread Mike Genezareth mentioned on new methods of propagation, Margaret is going to share with us some of her latest research, which fed into a very timely initiative to harness the power of search to connect people to legal help. She'll be talking through the basics of search engines' power for discoverability of legal info and what the strategy is to get legal info to be served up better. Margaret Hagan.
Hi, everyone. Thank you, Tony, for that wonderful introduction, and thank you, Jeanette. So I'll be talking today about one of the projects we've been digging into this past year at the Legal Design Lab here at the D School and the Law School at Stanford. And the driving questions behind this project is how we can make search engines a much more powerful and actionable force for people, lay people, who are searching for problems that they don't know have legal components, but that we as lawyers would know do. So how do we make their search engine results more actionable and more directive to get them to quality legal help? How do we give them the options that they might be able to weigh against each other and actions they can take based on the knowledge that they might have a legal issue? And how do we do this in ways that are engaging, that are understandable, and that are basically on their own terms, that are supportive to them as people in the world who are very busy and don't really want to go to a lawyer in the first place? So we've been doing user research where we give people tasks to do, legal tasks to try to resolve using the internet, or asking them about past experiences and using the internet to try to find legal help. And our findings are not very reassuring about the quality of the legal help internet as it stands right now. So first of all, the internet and search are really powerful. They're increasingly prominent as first means to try to find, is this a thing, the thing that I'm experiencing, whether it's around housing, around family law, divorce, child custody, consumer debt, all these kind of common consumer law issues we know are out there. People are increasingly showing up at search engines with questions about them. But the kinds of information they might get, even if they do land at kind of the legal universe of results, they want to find public official sites that are not commercial, that are ideally from a government agency or from a court, that will tell them what the law is, what their options are, what they might be eligible for. They want to make a game plan. They don't necessarily want to hire lawyers straight away. They're not using the internet necessarily to find a representative, but they want to get strategic and they want to get smart. And they want to do that from a government site. But what they currently find when they search, which is not a knock against Google or Bing or Yahoo or Yandex or the other search engines, it's a knock against us as lawyers and how we are structuring our websites, is that the search results are often jumbled, confusing, overwhelming. People can't find the information they need usually in the first hit, or if they do, they end up on a government or a court website that is not easy to navigate, that doesn't give them the clear initial game plan type of information that they want. They get caught in the weeds, or they get caught on the wrong kind of page, and they end up, if they're dedicated enough, having to scroll through and open up maybe 10, 15 different browser windows, try to collate information, trying to make a game plan based on all these different sources of information. So this is what our user research is finding. And so we as designers are always thinking, what if? So this is the type of vision that we have in our head. How do we get the actual search results page, or the voice that talks back to us as we use kind of more voice-based search on Alexa or Google Home or other products? How do we get those first results to be much clearer, official, jurisdiction-specific information that people can then take action on, rather than having to do an entire research process on their search engine? So how do we get, if you have a search like this, I have a felony from 1998, what do I do? How do we figure out that there might be a legal issue there, what that legal issue or option is called, and then lay out some standardized actionable information that can help people form a game plan. Not necessarily give them specific legal advice, but give them context, give them the right type of words, and make them aware that a jurisdiction does matter, calling back to Josh Lennon's point from before. So how do we actually get to a search results page that's like that? So what our plan here that we've been working on for the past year, it's 3 main overarching steps that I'll dig into. First, it's about creating a schema, not to get too jargony, but to basically standardize the information that's currently on court websites, legal aid websites, law help websites, but make it more structured so that it's more discoverable by search engines, so that search engines know what's on these pages, how to categorize it, and how to serve it up better. So that we then have the search engines be able to crawl these official this wealth of information that's currently on official sites, serve it up to people better, and involve more non-lawyers in this process, so get more of these search engines and social media giants to think about legal help and legal issues for their consumers. So what that looks like in practice, as a design lab, we're taking a design thinking approach to this, which means that we're involving lots of different stakeholders and trying to start from the end user's point of view. So that person who's on their mobile phone asking a question, or in their home asking Alexa, wherever they are. So they're at our core, these people who have potential legal issues they don't know about but are searching about. And then we've looped in a wide variety of other stakeholders. So people from Google, from Microsoft, and from other search, the people from courts and legal help, Pro Bono Net, LSC, all these other people who have all this great content but don't necessarily know how to get it out onto the search engines in the best way. So what we've been doing is been working with a group called schema.org. So you might not know about them, but they're a really cool nonprofit that's actually an unlikely alliance between Microsoft, Google, Yahoo, and Yandex. So engineers from all of those different companies have come together and created a central schema, a markup standardization language that webmasters can use to encode their data so that the search engines can know exactly what's on the different pages and serve it up correctly. This has not been used for legal, but it's been used for other analogous areas like personal finance and like medicine. So why don't we have this for legal? That's what we're doing with schema.org and these various stakeholders to try to figure out how we can apply the existing markup or creating new markup that we can then use to create legal standards for search engine results around legal help. The other thing we're doing is taking this user-centered approach to bridge how people talk about legal issues with how lawyers and courts talk about legal issues. So we're doing research into how people use phrases and terms to talk about things, and then pair those kind of user-centered terminologies or phrases with the legal issues. And then we're working with courts and with law help sites to figure out how best to encode the enormous amount of content they've got online and do it in automated fashion. This is the hard part. We're currently working on this, so if you have ideas, please come talk to us. And then we're working on what the actual search results pages should look like, so how we actually serve it up on the page, or maybe even over voice, what we can deliver to people. So let me show you a little bit into some of this. I won't go into all the details. But in terms of trying to connect the user's version, the folksonomy of legal problems, to the official lawyer version of problems, their ontology. So I never thought I would care about ontologies, but I really do now because structured information is enormously powerful. So this is schema.org, so please go check it out. It's really cool, and we're able to adapt things from other areas to law. So for example, why isn't every single legal help web page tagged up with what jurisdiction it applies to? So schema.org already has a tag called administrative area that we could then be using on every single legal help site to say, this is the county that this information applies to, or this is the state. A really quick, easy way with existing language that we could then just be putting in tags on every web page so that we at least have jurisdiction correct information being served up, if nothing else. And then we've been doing a lot of kind of design thinking workshops where we get people to say, if you are in the situation and you searched, what are some of the search terms you would use, and what type of information would you want to see? So we're trying to do this ground up version of how we link their version of problems and what type of information they want to see. So, and then we're doing a lot of research too about trying to see what kinds of searches people are doing, what kind of words they're using, and build that network analysis of the terminology out from there. The other area I'll give you a glimpse into is our search results design page. So this is my April 1st, April Fool's Day slide. I didn't actually post it because I wanted to save it for today, but this is one of my ideas. Why don't we just put cats on all the legal information, then people will actually look at it and might click on it, just like Law by Kittens. I'm not serious, but I kind of am. So this is one of our inspirations, is the medical type of information that's being served up on Google. As you can see, their priority box given, if you search anything in the search box related to Zika, you'll see this very well presented image plus official information about the Zika virus and the effects it might have. So that's one inspiration we're drawing from. Or if you are searching around election time, you'll have seen some very interesting presentations of official prioritized information about where to vote, how to vote. And this was funded by the Pew Foundation, who worked to get all of that information about polling places, requirements, all of that standardized and served up on Google. So if you searched anywhere in the US, you could find reliable, quality information without any ads or any long search results to browse through. And it was also on Facebook, too. So seeing that as an example of what are some of the low-hanging fruits that we could do that type of treatment on in legal help world, that we could use those models from medical and from voting. So again, Design Think, we've been doing a lot of sketching and blueprinting. We're currently at this type of design, but if you have ideas about that, please let us know too. We're still in the phase of coming up with our recommended search results page design. So with that, I think I'm done. Thank you for your attention. I'm glad to talk later. Yeah.
Thank you, Margaret, for that inspiring example of user-centered design and collaboration being brought to bear for access to legal help. Next, we're delighted to have with us Judy Perry-Martinez, currently Special Advisor at the American Bar Association Center for Innovation. I was fortunate to spend a few hours with Judy yesterday and began to understand what a unique perspective Judy is going to be sharing with us. From 2014 to 2016, she served as the chair of the ABA's Presidential Commission on the Future of Legal Services. But she's also previously served as chair of divisions supporting young lawyers, commissions on women in the profession, and on domestic violence, as well as participating in ABA initiatives around attorney-client privilege, racial and ethnic diversity, and world justice. Judy brought to each of these appointments a wealth of experience from both law firm and in-house practice and executive management. She has witnessed the evolution of corporate culture from lawyers being separate from the corporate body towards taking on a much more integral role around the boardroom table. Taking these insights around the need for interdisciplinary collaboration to truly innovate in the legal system, Judy is going to share with us some of the initiatives and outcomes from the tremendous work being done at the ABA on the future of legal services. Judy Perry-Martinez.
So good afternoon, and thank you, Margaret, and thank you, Tony, for that nice introduction. The first revolution is when you change your mind about how you look at things and see that there might be another way to look at it that you have not been shown. Those words of American soul and jazz poet Gil Scott-Heron, which for those of you in the audience who are Homeland fans, you might hear those words each week in the introduction to the show, are ones that keep coming to mind for me. Through the work and collaboration and sheer determination of many of you sitting in this room today and others before you, efforts to embrace innovation in technology and the delivery of legal services were begun decades ago. But the words of Gil Scott-Heron come to mind when I think about how we lawyers, as members of a profession steeped in tradition, in cultures, in rules, in regulations, and customs, must individually and collectively examine the opportunities made possible by the technologies and the new ways of thinking about delivery of legal services that innovators like you in this room are laying before us. And we must help our colleagues, particularly those from the traditional practice of law, understand that there might be another way to look at things, about how we can deliver legal services that they have not yet been shown. And the resistance to change has been fierce. There's been no doubt about it. And you can expect that it will remain fierce from some corners. The law is a great profession that has high standards of competence and ethics, and it is steeped in rules and regulations and also traditions. And though many are earnest in their rightful quest to uphold those critical standards, there are unnecessary and unintended consequences in upholding some of the traditions and rules that may mean that we are missing out on the changes that could result in greater access to justice. The minds of those who perceive themselves as the greatest defenders and champions of the profession are often the last places where that first revolution, the revolution of changing your mind about how one looks at things, is born. And helping lawyers and judges look at things that previously have not been shown to them was a core mandate of the American Bar Association Commission on the Future of Legal Services, helping them realize that there might be another way to envision not only the future of legal services and the law itself, but to bring forth the best of the past in terms of the profession is the challenge that all of us who care about access to justice must now meet, and meet together. And of those of you who have led the technology-driven innovation that our legal sector has seen, also can be among those who come to understand that there might be another way to look at things, as the resistance from those in the traditional practice of law, which I admit can often be frustrating, can also strengthen how you innovate if it brings forward the best of what the profession can offer in service, not to itself, but to the public. The ABA Commission on the Future of Legal Services rendered its final report in 2016, August, and the report contains both findings and recommendations. Like any awaited writing of major import, the report has its admirers and its detractors, each equally important, as their divergent views and perspectives and raised voices are exactly what the Commission wanted the report to be: a catalyst for thoughtful dialogue and ultimately change that will benefit the public. Three key findings, and there are several findings in the report, but three key findings in the report are particularly noteworthy for you today. The traditional law practice business model constrains innovations that would provide greater access to and enhance the delivery of legal services. Number two, the legal profession's resistance to change hinders additional innovations. And number three, new providers of legal services are proliferating and creating additional choices for consumers and lawyers. The first finding is noteworthy because it suggests that the law firm delivery model of one lawyer for one client is not sustainable in many circumstances. It is an imperative that things must change if we are going to provide greater access to justice. The second finding should grab your attention, not because of what it says, it's not a surprise to anyone in this room, but because some would say never before has any element of the established bar been willing to acknowledge its resistance to change and how it may hinder innovation. But don't be fooled, many within the legal profession still don't see it that way, but the Commission did. The bottom line is that we must all work together to better understand how we can shape the future of law to create greater access to justice. And how do we do that? Well, after issuing white papers and receiving hundreds of sets of comments, sponsoring public hearings, holding and participating in 85 grassroots events across the country, gaining the benefit of a major summit held right here at Stanford in this room in May of 2015, and harvesting the thoughts and insights of 15 highly regarded academics, some of whom are sitting in this room, on what we need to know about the future of legal services as published in a special edition of the University of South Carolina Law Review, And after, most importantly, in-depth discussions and debates among the 39 members of the commission, we arrived at 12 major recommendations to guide those who care about access to justice. While each of the recommendations, the 12, are distinctly critical in order to change how we go about legal services, how they are delivered, but to do so in a way that will provide greater access to justice, I will focus on 4 that warrant your particular attention. Courts should consider adopting the ABA model rules of regulatory objectives for the provision of legal services. Courts should examine, and if they deem appropriate and beneficial to providing greater access to competent legal services, adopt rules and procedures for judicially authorized and regulated legal service providers. And states should explore how legal services are delivered by entities that employ new technologies and then assess the benefits and risk to the public associated with those services. And lastly, continued exploration of alternative business structures will be useful, and where ABS is allowed in a state, evidence and data regarding the risk and benefits associated with ABS should be developed and assessed. Report said adopt, explore and examine, 3 words of action, 3 actions that will change the course of legal services delivery, 3 reasons why the report of the Commission is the tool to enable you, each of you in this room, to personally take on the challenge and invest your time and energy in assuring greater access to justice. State bar associations are using it, the courts are using it, and lawyers and others who are leaders are using it. They are using the report to change the conversation, and the conversation has changed. And the organized bar needs you, each and every one of you, to be a part of the conversation that is now ongoing. Through the ABA model regulatory objectives, state Supreme Courts now have a framework to examine both current and proposed regulations. The adoption of the ABA model regulatory objectives did not come about easily. The dialogue on the regulatory objectives and the discussions that led up to the debate on the House floor of the ABA House of Delegates was intense, and the debate in the House was one of the best I've seen in my 25 years as a House member. There was an amendment to assure that the resolution itself did not change ABA policy on non-lawyer ownership and core values, but the House adopted the ABA model regulatory objectives, reflecting a new approach to thinking about the delivery of legal services. It is a new approach because the regulatory objectives focus on protecting the public and not on the profession. The debate on the regulatory objectives was, and I don't think I overstate this, was a watershed moment for the ABA and for the profession, where the regulatory objectives lead us next, with your involvement, can be a watershed moment for the public. Significantly, the Conference of Chief Justices passed its own resolution recommending to its members, the chiefs, that they consider the model regulatory objectives. Bar associations and partnerships with courts are pushing out CLEs that talk about futures left and right. They're covering subject matter such as CLEO and ABA Blueprint that can assist lawyers in their practices, but they're also hosting full-blown discussions about ABS and potential other ways to increase access. Law schools and bar associations, like we heard about a little earlier, are hosting incubators for unemployed and underemployed lawyers, and they're passing resolutions in support of really taking a look at the curriculum development of non-lawyer legal service providers. Indeed, the conversation has changed. And there is one further recommendation in the report that I want to briefly share with you. It's one that has really caught fire, and for good reason, that the ABA establish a Center for Innovation. The Board of Governors of the ABA immediately authorized this center and made a major investment in its creation. It is fully staffed with a talented team. It is chaired by rock-steady Dean Andy Perlman of Suffolk Law School, and it is governed by, I would suggest to you, top minds in legal services delivery, design thinking, legal education, policy, and computer science, such as Margaret Hagan, Sandy Pentland at MIT, Dean Margaret Morrow at Harvard, and Jim Sandman, president of the Legal Services Corporation, who are dedicating enormous amounts of hours, not only in the past to the commission, but now to the center. The center is designed to encourage and accelerate innovations that improve the affordability, effectiveness, efficiency, and accessibility of both criminal and civil legal services. It is driving innovation in the legal profession to the delivery of legal services and the justice system. It's located at the ABA headquarters in Chicago, and it provides a space for collaboration, experimentation, cross-disciplinary learning, innovative thinking, and project acceleration. It's staffed up, it's already sponsoring an array of pop-up projects and tools, and it is geared to host its first class of Next-Gen Fellows and Innovation Fellows commencing this August. It's collaborating with companies including Cisco, Microsoft, Fastcase, several major law schools, design programs at IIT School of Design, MIT, and Stanford, state bar associations, legal tech companies, innovators, law firms, and ABA entities on projects and programs and curriculum. It's focused, it's integrated, it's strategic, it's a resourced access with provocative thought and innovation, which will have been driven out from its center, from within and both outside the profession. So stay tuned. The first revolution, lawyers changing their minds about how they look at the delivery of legal services, because they are seeing for the first time that there might just be another way to look at things, is, as Sarah Thornton said this morning, in high development. Thank you very much.
Thank you, Judy. You all heard it here first. The revolution. It's happening. Next, I'm honored to introduce someone who really needs no introduction. Jim Sandman, president of the Legal Services Corporation since 2011. He practiced with Arnold & Porter for 30 years, serving a decade as the firm's managing partner. And from 2007 to 2011, he was the general counsel for the District of Columbia Public Schools. He was president of the DC Bar from 2006 to 2007 and served on the bar's board of governors from 2003 to 2008, where he maintains leadership roles on their pro bono program committees. He has a storied history of awards and recognitions, but I imagine few things are more important to Jim right now than the current and incredibly important work that legal aid organizations all across the nation are providing, thanks to the funding and administration provided by the LSC. All that is under threat. The opportunity and the empowerment that having access to legal services creates is under threat. Last year, Jim gave the FutureLaw audience a rousing keynote on the barriers to adoption and progress, and also about empowering agents of change. While over the last few decades, in aggregate, we have seen greater material abundance and progress, what happens when people get left behind? What happens when they feel left behind? How do we share that prosperity? Please join me in welcoming Jim Sandman to give us an update on the 2017 challenges and opportunities and the role of the LSC.
Thank you all, and thank you for your support of the Legal Services Corporation. We're not going anywhere. LSC has been around for 42 years, and I know we're going to be around for generations to come. We have strong bipartisan support in Congress. We've had an outpouring of support from across the United States in recent weeks. I'm an optimist. I love my job, and I plan to keep it. One request, would you please stop looking at me as if I've risen from the dead? The theme of my keynote here last year was how to accelerate the adoption of technology in law. My premise was that when it comes to the use of technology to serve customers, law is a laggard, not a leader. The problem, I believe, is not a lack of innovation. It's a lack of adoption at scale. And innovation without adoption is for naught. The practice of law today, in the 18th year of the 21st century, looks to me pretty much like what it looked like in the 20th century, and in some respects, like the 19th. I came across an example last week that I'd like to share with you. Kentucky has a website for people who are unrepresented in litigation. There's a page titled Self-Help Divorce Options for Kentucky Residents. The subheading is Required VS 300 Form, Certificate of Divorce. It reads as follows. When you file for divorce in Kentucky, you must file a VS 300 form with the court clerk. While all other self-help forms may be submitted with handwritten entries, the VS 300 must be typed. You must complete the form online at this link. You must print this document on 25% cotton bond paper with a visible watermark. You can purchase this thick resume-type paper at most office supply and retail department stores. I did a little survey in my office after I read this to see how many people knew what 25% cotton bond paper with a visible watermark was. Might not surprise you to hear there was a generational divide. Younger people think of a watermark as that draft imprint on Microsoft Word. The idea of holding the paper up to the light was not something they were familiar with. But there's a more important barrier here. You have to buy 25% cotton bond paper in a ream. You know what a ream of 25% cotton bond paper costs? Between $19 and $30. Imagine you're a poor person seeking a divorce in Kentucky. That can be a showstopper. But that's what law in the United States is for many in 2017. I'd like to follow up on my remarks last year when I tried to identify 10 barriers to the adoption of technology in law and then 10 levers of power or agents of change that might be engaged to accelerate adoption at scale. This year, I'd like to identify my top 5 potential allies to enlist. In doing so, I'm mindful of Professor Hadfield's admonition this morning. To accomplish change, you need to engage others beyond the usual law tech worlds. You can't just use the lawyers. As I list each of my 5 potential allies and agents of change, please ask yourself, have I engaged with them? Do I know who they are, what they do, and how they might help? As a little refresher, I'd just like to go over my 10 barriers to adoption. I don't claim that they're exhaustive. They're the list I came up with. The first is a lawyer-administered regulatory system that too often is more protective of lawyers than consumers, is conservative, slow to act and react, and casts a pall of uncertainty over the possibility of change that deters investment. Second, a judicial system that disperses authority and decision-making across the court systems of 50 states plus the federal courts. Third, insufficient capital to support innovation at scale. Fourth, a pricing model, the billable hour, that penalizes efficiency. Fifth, law firm structures that impede strong management and quick innovation. Sixth, malpractice insurance environments that discourage new processes. Seventh, a legal system based on precedent, which is inherently opposed to change. Eighth, legal education that, as a general matter, provides no grounding in management, efficiency, client service, or user focus. Now, I acknowledge what Jeanette said about improvements being made in legal education. A lot of the courses that deal with these issues are electives, and they reach only a fraction of the law student population. Ninth, a professional culture that emphasizes lawyerly judgment and emphasizes how each case is different. And finally, there's a problem with who becomes lawyers. I don't know whether it's as they came to law school or what law school does to them, but lawyers are risk averse. That's not an environment conducive to the adoption of innovations. So here are the 5 potential allies that I suggest we try to enlist to accelerate, to force the adoption of technology. First, I recommend working with the National Center for State Courts and its affiliated entities, the Conference of Chief Justices and the Conference of State Court Administrators. They have an incentive to try to improve processes that are currently overwhelmed with unrepresented litigants. In courthouses across the United States today, more than 90% of tenants in eviction cases have no lawyer, even though more than 90% of landlords do. It is common across the United States today for the majority of people appearing in family courts to have no lawyers. That reality slows things down. It complicates work for judges and for court administrators. Mary McQueen is the president of the National Center for State Courts. I think she's an innovator and smart and very receptive to change. The vice president for research and technology there, Tom Clark, is both a visionary and a pragmatist. He coined this saying about courts: courts, adopting yesterday's technology tomorrow. Don't you want to work with someone like that? They can make things happen. They're currently working to implement what's called the 100% Access Initiative, something that originated at the Technology Summit that the Legal Services Corporation hosted in 2012 and 13, and that was subsequently adopted in a resolution by the Conference of Chief Justices and the Conference of State Court Administrators. The goal is to use technology to provide what the resolution calls some form of effective assistance to 100% of people seeking help with an essential civil legal need. Some form of effective assistance. The idea is turn no one away with nothing, which is what happens all too often today, and to offer a spectrum of services tailored to the circumstances of the user, depending on things like the nature of the matter, what's at stake, whether the opponent is represented, what resources are available, to rationalize the system of providing available resources to people in need. A second category that I'd propose working with is the Association of Corporate Counsel and the Association of General Counsel. Yes, they're lawyers, but they're also the client interface for their outside lawyers and law firms. They have an interest, an economic interest in efficiency. They can be helpful in pushing adoption, requiring adoption by their outside counsel, and they can also be helpful in advocating for regulatory change. Third, look to the insurance companies that pay the legal bills for their insureds. They too have an economic interest in improving efficiency and reducing costs. If you have an innovation that, if adopted by lawyers for insured businesses, would increase their efficiency and reduce their costs, have you talked to the insurers about it? They also can be helpful in pursuing a regulatory agenda. Fourth, think about organizations that rank law firms like BTI Consulting and America Lawyer Media. I think it might have been BTI that generated the statistics that Professor Hadfield showed this morning, that 70% of them don't recommend their law firms. Law firms pay attention to league tables, as they refer to them, rankings. There aren't currently rankings that I'm familiar with of the adoption of technology by lawyers and law firms, but clients should have a strong interest in that. And if they're given an opportunity to shine a spotlight on those that are doing well, and maybe to shame those that aren't doing so well, that could drive some additional innovation. And finally, don't get upset, Judy. Think about state legislatures and state attorneys general who have a consumer protection initiative. The current regulatory barriers, which purport to be based on principles of consumer protection, are often just the opposite. They limit consumer choice, they drive up consumer costs, and they can prevent the adoption of solutions that would be helpful to consumers, particularly to those who cannot afford a lawyer. There are ways around the current regulatory systems when they are failing in their consumer protection mission. If you want to change the rules, This may be one of the fastest routes. It should be on the table if the existing regulatory systems aren't working. These entities can help drive transformational change. They can be important allies. They have access to power and to consumer sentiment that lawyers themselves can't reach. One thing is clear to me. The status quo is completely unacceptable. Our legal system today fails far too many people. And it fails not only those who can't afford to pay, but in many respects it fails those who can by making their costs unacceptably high. I just don't think it's okay to have a legal system where so many people are forced to navigate it on their own. What they confront is a legal system created by lawyers for lawyers, constructed at every turn on the assumption that you have a lawyer. If you do have a lawyer, it generally works okay. If you don't, it can be a disaster. People who are not trained in the rules of civil procedure and the rules of evidence really don't stand a prayer of putting on a claim or a defense in a court of law. Imagine yourself trying to do that. Think about what it was like, those of you who are litigators, the first time you had to do it as a lawyer. That was plenty scary enough. Think about what it would be like if you'd never completed college, let alone law school, or if you hadn't completed high school. We have to do something to pick up the pace. Thank you.
Thank you, Jim. Thank you for your work. With leaders like yourself at the helm, I hope we can all inspire the legal profession to fulfill their role as the backbone of an inclusive civil society. As I turn now to our next speaker, I want to touch on a phenomenal conversation I had yesterday evening at the speaker dinner with Lucy Endell-Basley at Microsoft. She heads up their legal operations, and essentially you'll be hearing from her in the next session, but she was telling me around how efficiency techniques and better data management processes are being applied in legal operations departments of major corporations like Microsoft, but also how those techniques could translate to the access to justice gap, which is why it's tremendous to see corporations like Microsoft partnering with the LSC in an effort to create statewide access portals. And our next speaker, Adam Stock, is going to share with us his perspectives on a central component in these emerging efficiency techniques, the use of matter standards. Adam Stock is Chief Marketing and Client Services Officer at Allen Matkins, an AmLaw 200 law firm. At the law firms, he provides value to clients through innovative marketing and technology use. He's a frequent speaker on law firm client development, technology, and visual communication. Before joining the legal profession, Adam hired outside law firms as a high technology executive for Adobe Systems, Electronics for Imaging, and several other startup companies. He's also a member of several law firm standards committees, and he also helped run the Legal Marketing Technology Conference for the last 5 years. He served as an LMA board and past president of the LMA, and he's a board member of the Legal Services and Sales Organization, and a fellow of the College of Law Practice Management. What I personally like best of all, though, is he received his BA in computer science, albeit from Yale University. Adam Stock, why law firms should embrace matter standards.
Thanks so much. That was an amazing talk that you just gave. Hopefully I can shine some light on some work that I think, an effort that is being driven largely by big law and big clients. And this has to do in the area of matter standards. As I said, not only am I a CMO at an AmLaw 200 law firm, but I'm also co-chair of the Sally Matter Standards Committee. And so while they were giving me, the title of my talk was Why Law Firms Should Embrace Matter Standards, I'd like to touch on that, but really there is part of a solution underway already, and we really would like we'd like your help in making this happen. I think what's really driving this is the economics of big law is being driven to be more efficient. I mean, it's just very straightforward. whether or not, no matter what we say, the numbers are clear. I think this was a similar slide that we saw in our keynote presentation, that while demand for legal service has gone up, demand for big law has been flat. And what we know, as has been said over and over again, is participants really are reviewing who their legal providers are. That we really are not providing the quality, we're not providing the kind of service and costs that we need to do. And that we have many more many more choices for legal services. And if you are working inside of a law firm, it's not only all these other providers, but with the internet, legal used to be very local. It's not local anymore, right? You can Google something and you can find law firms. So we have more competition from other law firms. But of course, we have alternative legal service providers. So much of legal is going in-house. Our pricing, our billable hour has really gotten in the way of all of this. You're going to hear from some clock members in the next session, and at least the latest statistics that I've seen is I think in-house corporate has now become larger than legal corporate. And of course, we've got technology assistance, and I think those of us and I'll talk a bit about Sally and that effort. It's been an honor to work with the people in large law who are very motivated to change legal, and we are all trying to adopt technology. And I think one of the big issues that we've got with this is that there really aren't standards. We've got to start somewhere. The other thing, of course, is that buyers are becoming a lot more sophisticated about what they're buying and what things should cost. Again, we'll hear a lot more about that. And I don't think that we can keep approaching things the way that we are, in the sense that some things are very commoditized. And what we're seeing with our customers is they're taking those more commoditized things in-house. Right, and so we've got to really segment, and if you've ever read The Innovator's Dilemma, we're going to end up a lot like those tech companies that don't innovate. And what we really need to do is we need to innovate, we need to understand how to provide more commodity services at lower prices, and provide better service and provide more self-service. And while this is happening, I would say from the point of view of big law, I think it has a ripple effect throughout the entire legal industry, because I think it will make all of law better. So let's talk a little bit about how this is done. I think the ACC has really done a major service to us, right? Really what changed in 2008 was the downturn, and it started with the ACC, and we're seeing it with the legal operations movement that we see now, which is there basically was customer revolt. They have many more different options. Boy, and we have a typo there, look at that. And, but basically they said, here are 6 different ways that we really can do a better job of providing legal services. But if we're trying to implement those, and many of us in law firms are trying to implement those, what we really lack is a common vocabulary. And I found this very interesting slide from the ACC, it was mentioned before. And really the big issue that we have is we have all of this very useful data in our law firms. We heard a lot about big data. We heard about the data that people are harvesting outside on the internet out of public records. But we've got a wealth of data inside of each of our law firms. And because of confidentiality reasons, it's very hard for us to share it. But we don't even use it correctly inside the firm. And so the big effort that we're focusing on is how do we reuse work product? How do we provide things more efficiently? And so what we've done is there was a group of people of us who got together. It started actually at the P3 conference 2 years ago. At the P3 conference, this is the conference of pricing people in large law firms, sort of a new phenomenon. But what's amazing about that conference is how quickly it's grown. Again, because customers want alternative fees. And as soon as you introduce the idea of alternative fees, you can no longer be inefficient, right? Now it's in your interest to be efficient. What's happened with all of these pricing people is it's fallen at their feet to figure out how can we be more efficient. And so what we said is, gee, we probably think we need a standard. And so the question was asked in that group. And the response was so overwhelming that we started this effort. And what was interesting about this effort is it involves lots of law firms, but it also involves lots of our clients, and it involves a lot of technology providers. And it's a coming together of people to really solve this problem. It's to come up with a common vocabulary across legal operations to improve our processes and efficiencies. Well, what do I mean by that? Well, imagine that every library they didn't have the Dewey Decimal System, they used different systems to categorize things. Well, that's the state of law today. We do not have a common way that we define what we do. And I like to liken this to, and so we started the Matter Standards group. And what we're trying to do here is something very simple. If you look at most industries, they have something called SKUs, right? Stocking units. And they have a way of coding these so that if I'm in one store and I'm buying this nail, I know what that is, right? And they're interchangeable, and at least I can identify that it's this kind of nail. I know that I got the right nail. Well, this is a real problem when you think you're buying legal services or you're offering legal services. So our goal is really to do that same thing for legal services. And we're in the early phases of it. We're setting up an independent entity, and we actually have a framework, which I'll describe. But the idea is very simple, is that you can tag whatever it is that you do with a kind of matter that was associated with it. Okay, so if you think about it, this will go anything from, well, how many of this kind of matter have we done? And it helps not only if you're a law firm and you're trying to pitch for business, but if you're running a legal operations in a large company, you want to know what professionals you have that are best suited or have the most experience in addressing that. And for that matter, if every document were then tagged with this, then you could find your work product better. You know, we heard a lot about artificial intelligence and all the great things that it can do. I just came from the legal marketing conference, annual conference, and there was this wonderful panel on AI, and there were some people who showed very early work that they were doing. It was truly amazing. And then there was one really telling comment, which is they said, well, to get these results, we spent 90% of our time cleaning up the data and 10% on the AI. And that talks to how bad our data is. And so what's really great about this approach, as I said, is the outpouring of help that we've gotten from these different constituencies. Because not only does this help in the procurement or the buying and the selling of legal services, it helps in the pricing, it helps also in the project management, which is a key to efficiency. But this is really good for the consumers, it's great for law firms, and what's really wonderful is that there are all of these innovative companies that are there to help us. So I wanted to take you through a typical scenario that I and my department go through all the time. On a very personal note, but this is very illustrative of what this is meant to solve. So a client will come to us and they say, well, what experience does your law firm have in doing this kind of law? Well, what do we do now? Well, we don't really have all of our matters tagged with this, so we scramble and we find our Excel spreadsheets and we speak to attorneys and it's all very anecdotal. And then they might ask, well, who are the best attorneys to assign to it? Well, it's not the attorney that answered first, right? It really should be based on some sort of objective quality of experience. Well, of course, the next question they ask is, well, we want an alternative fee. What would this cost? Well, if we can't go to our time and billing system to go ahead and say, well, what did the last 10 of these cost? We cannot really give them a very intelligent answer. And furthermore, they're coming to expect this data. They're saying, well, you tell us that these are the best attorneys. Well, what did they work on? So they really want, our whole industry, actually our whole world is becoming a lot more data-driven, and they actually want the proof. And then finally, when it comes to actually executing on what we promised to do, we need this information for project management. And so again, that's the goal of the system. So what we did is we formed this organization called SALLY, standing for the Standards Advancement for the Legal Industry. You'll be hearing a lot more about it in the second half of this year. These are the organizations that are behind it. The organizations on the top have committed money to it, and we have participation by ACC, CLOC, and AALL, but ALA, ILTA, and LMA are involved and have put money into it. So let me tell you a little bit about the coding standard. And as I said, this is a first step, but we think the first step is really just to do matters. And our goals are again, very straightforward. This should be an open standard. It's free and available to all stakeholders. It needs to be industry-driven. This is why we are going and we've taken the time to form this organization that can't really be controlled by any one group, and it's managed by an independent nonprofit industry organization. The code set will be hierarchical, have multiple levels of specificity. We understand that the world changes and that different applications need that. It will be extensible, because what we've actually found is a lot of different companies, a lot of different law firms are solving this problem, and we want to make sure that we get adoption, because adoption is a very big part of that. And finally, it will be practical, is that it will come with associated sample implementations and user interfaces. We're committed to providing a RESTful API. Yes, it's not like other legal standards where you go to their website and what you get is a PDF with a bunch of codes and you don't know what to do with them. We're here, we're in Silicon Valley, we're committed to doing that. And of course, the other thing that we're doing is we're trying to take a use case driven approach. And so these are the kinds of questions that we hope that the code sets help to answer initially, and there are many that go from there, which is, as I said, what experience does our law firm or what experience does our department have in handling a certain kind of matter? Which attorneys have the most experience, and what model documents should we be using so we can access those a lot more quickly? So this is a simplified view of it, but essentially we've identified to this point 4 axes, right? The practice in the area of law, the process or the service, right, which goes to process management, the industry and the market of the players or of the parties that are involved. They're very important. Doing a patent for a biotech company is fundamentally different from doing a patent for a software company. The value, the amount of effort they want to put in, you really do need to understand the context of the parties. And of course, as we heard earlier in the chatbot, you better have the jurisdiction and the location. Those are terribly, terribly important. And so here is an example of the coding. And it really, this would show you an example of the result of the coding. So you could actually look at this, and my question to you is, if you had these things filled in, can you tell what kind of a matter this is, right? If you were a law firm, could you get a sense of what you might charge for this? You might have a bunch of other questions. If you had documents that you were filing, does this provide you useful information? And I think the answer to all of this is yes. It's certainly better than what we all have now. So our effort here is to provide a basic standard. I think there are many, many other standards that are in place, but I'm very heartened by the fact that so many law firms, so many clients, and so many service providers to us, business technology service providers, have come together to help us with this effort. Thank you.
Thank you, Adam. Just to take a leaf out of Margaret's book, I think my refrain there is open standards, open standards, open standards. Thank you. So I'm not sure if we have time right now for questions. It's okay. If we have 1 or 2 questions, please. We've got time for.
My name is David Fisher. I'm the founder and CEO of a company called Provatum. Question for Jim. Is the budget of your organization about $375 million? I think I looked it up online.
$385 million. It's gone up by $10 million a year in each of the last 3 years, including in the last Congress when Republicans controlled both the House and the Senate. Thank you for the question.
So I guess my question is, if we're doing things like applying a medical device tax to fund, or I think it may have been repealed, but for Obamacare, which was really a tax on innovation, but still it was levied to raise about $1 billion. By my calculation, the top 100 law firms in the United States have gross revenues about $50 billion, largely paid by, I think, the overrepresented, so wealthy corporations, Fortune 1000, so on and so forth. Why not just apply an excise tax, for the top end of the legal market to take care of the bottom end, just like we do with medicine?
Well, I think big law firms could and should be doing more to support legal services, but I don't agree with the premise that it's the responsibility of the legal profession to deal with what I think is the first duty of government. Thomas Jefferson said the most sacred of the duties of government is to do equal and impartial justice to all its citizens. I don't think we should be outsourcing that responsibility. I think you can find that sentiment expressed in the Federalist Papers, Federalist number 51, James Madison. The first duty of government is justice. So I do think that we could do more, but the notion that the big firm segment of the legal profession should have to bear the burden of it, I don't think recognizes the issue for what it is. It's a societal issue. It's about the rule of law. I think we need to disperse the responsibility more widely, but I think we need to recognize that government has a very important role to play there. But I don't, you'll never hear me say the big law couldn't be doing a lot more. Thank you. I like the way you think.
Please.
Hi, Tom Gordon with Responsive Law. My question is for Judy Perry-Martinez. I think that the findings of the, sorry, I'm getting a lot of feedback off of this. I think that the findings of the commission were spot on in identifying what's wrong with regulation of the legal profession. And I was wondering why then the recommendations stopped short by asking for further exploration, for examination, for consideration, when that seemed to me that was what the commission was doing for 2 years. So why were the recommendations not phrased more strongly to ask that these things actually be implemented rather than just considered?
So thanks for the question. I think a few things. Number one, as you know, the ABA is not a regulator. It is the courts and the decision-making with regard to regulation on whether there should be certain forms allowed, or whether there should be non-lawyer ownership, or whether there should be judicially authorized legal service providers, is up to each and every state court, the highest court of that state, to make that determination. So one of the things we did was we did recommend that there would be judicially authorized legal service providers, and that's in one of the recommendations that I highlighted today. As to ABS, for that one, for instance, we didn't see the data that we thought we needed to see with regard to the fact of whether there'd be risk of harm to the public. Certainly the UK has taken a different tack and moved out on it, and playing it as they go. But it was a determination of the commission that we should get more data, and we are doing that. We are trying to do that in the places where it is allowed. That is right now only in forms in DC and in Washington State with regard to the triple LTs. And we urge caution with regard to any regulation with online service providers or with internet platforms, because we did make some statements in the report that we thought that significant regulation of those entities could in fact hinder innovation. So, you know, the bottom line is that the commission had before it some decisions to make, and we deliberated, we listened. For every person who thought we should have gone farther, believe me, there's a person within the profession who thinks we went too far. And as a consequence, we believe that what we did was, as I said, give the catalyst for change and for conversations that need to be had in the future.
Thank you for the question. I have one short announcement, which is that you should all find on your seats a blue evaluation form. If you would be kind enough to fill it out and leave it with a CodeX staff member on your way out, that would be most appreciated. Please join me in thanking Jeanette, Margaret, Judy, Jim, and Adam. So wonderful.